Tēnā koutou katoa. My name is Joel Colón-Ríos. I am director of the New Zealand Centre for Public Law and a professor here at the Herenga Waka, Victoria University of Wellington. This is episode 4 of the Lives in New Zealand Public Law series. This series is usually biographical, but today we'll be doing something a bit different. Today's episode will be organized around a specific topic, the past, present, and future of the New Zealand Constitution. And it is difficult to find a better guest to discuss it, Sir Geoffrey Palmer. Tēnā koe, Sir Geoffrey. We're very happy to have you here with us.
Thank you so much, Joel.
Thank you. So my first question is quite perhaps very basic, but also in some ways probably the most difficult question, which is what is a constitution?
Well, there are quite a lot of different ways of looking at that question, but actually what a constitution is a system of fundamental rules that tell you how power is distributed in a state. New Zealand is, of course, a state, and it has sovereign power over its own territory, and it makes laws. So the question that a constitution solves is, who has the authority to make law, who has the authority to tax, and what checks and balances are there against the use of power, what limits are placed by the Constitution on the use of power, and what are the purposes of government, which is sometimes something that constitutions tell us something about. A couple of British political scientists put it pretty well. They said a written, or more properly a codified constitution, provides a clear, accessible and coherent account of the body of fundamental rules and principles according to which a state and society are constituted and governed. In addition, it defines the powers of the institutions of government and sets out the rights of individuals and their responsibilities, while any constitution comprises words on a page, those who live under it and who make public decisions give it life and substance. New Zealand, like other countries, has a constitution. But unlike other countries, you can't find the New Zealand Constitution in any single place. What you have to do in New Zealand the real trouble for New Zealand is that it's difficult for people to find it. People don't know where to locate our constitution, and that makes public education of how our system of government works exceedingly difficult. It's a sort of mystery to most people. If you go down Lambton Quay and ask what's the New Zealand Constitution, you'll get some pretty funny answers, and you teach public law, you'll know that. Now, it is exceptional around the world for constitutions to be structured like that. Well, there are only three that are really comparable to us: Israel, the United Kingdom, and us. Three outliers in constitutional terms. Don't write it down. Now, of course, the one New Zealand scholar in 2006, I think it was my son Matthew, found that the New Zealand Constitution is located in 45 Acts of Parliament, including 6 passed in England, 12 international treaties, 9 areas of common law, 8 constitutional conventions, 3.5 executive instruments, and 1 prerogative instrument, and 1 legislative instrument, and half a judicial instrument. Now, you're getting into considerable complexity then, because actually the New Zealand Constitution consists of some law and some constitutional conventions. And the best way of trying to find these things is to look at the Cabinet Manual, which is a publicly available document, but not all the conventions in it and not all the laws in it either. It's just a ministerial guide to how ministers are supposed to do their work, because there is considerable difficulty in looking at what the law is on many aspects. We have a Constitution Act of 1986 which came about by accident, because way back in 1852 New Zealand had conferred upon it by the Imperial Parliament at Westminster the Constitution Act 1852. It was a big, long constitution, and it looked like a written constitution. And to some extent it was, because the New Zealand government had to keep within the powers that act had. But the New Zealand government was given power to amend it, and it amended it a lot. And it got rid of provincial government. In 1876, we had a system of provinces, elected people who made decisions. They made laws. Some of those laws are still on the books. And the thing is that then, over time, New Zealand became a more self-reliant nation, and it signed the Treaty of Versailles as a separate nation at the end of the First World War. And then came the Statute of Westminster in 1931, which gave the Dominions independence, but New Zealand didn't adopt that because New Zealand was tied to the apron strings of Mother Britain and liked that. Our trade went that way too. So, in a strange, looking back on it, it's very strange, we didn't adopt the Statute of Westminster until 1947, after the Second World War. So the Constitution Act of 1852 passed in London. By the time I started teaching constitutional law here, had 12 provisions in it. And all the rest had been taken away, but nothing was put in their place. And so you couldn't understand anything much about the government of New Zealand by looking at what was left of the 1852 Constitution Act. Now, when I got into politics, we had something of a constitutional crisis in 1984 because the Minister of Finance, Sir Robert Muldoon, refused to devalue the dollar, and there'd been a run on the dollar during the election campaign. And in the end, the government that won the election, the fourth Labour government, wanted to devalue, but it hadn't been sworn into office yet because there was a provision in our law, the Civil List Act, that said you had to count all the votes and had the sick votes and all the other votes, and you couldn't say who won yet. So a new constitutional convention was then invented by the Deputy Prime Minister and Attorney General, the Honourable Jim Macleay, now Sir James Macleay, who said, we'll find a constitutional convention. There was one in Australia, so they followed it, and the government of Sir Robert Muldoon followed the policy of the incoming government on devaluation, and it put through the advice that should happen, and it was done in that way. But it seemed clear to me that you couldn't go on like that. So we changed the law so that you could do that sort of thing more readily after a general election. But I also took the opportunity to get a group of officials, including Sir Kenneth Keith from this university, and internal senior officials, to look at whether we needed a new Constitution Act. And we got a new Constitution Act as a result of that. That was enacted in 1986. And what it did was to set out some important principles and law. It was law, enacted law. Now, a constitutional convention, which I've just been discussed, is not law. It's a custom. It's not probably legally enforceable in a court, and it may or may not be followed. You can't be sure. And a lot of the whole of cabinet government in New Zealand is dealt with by constitutional convention. You will search the New Zealand statute book high and low, you'll never find a reference to cabinet there. You'll find a reference to ministers, and you'll find a reference to the Executive Council, but you will not find cabinet. And yet we have a system of cabinet government. Cabinet is the apex of power in this system in New Zealand, and yet it's not a creature of law. Well, now, obviously, we needed to have, any constitution has, a way of having a head of state with some powers of the head of state. The Queen is the head of state in New Zealand. The King now lives in London, and as the Queen did, and is represented in New Zealand by a Governor-General, appointed on the nomination of the New Zealand government and agreed to by the monarchy. Now, the monarch has certain powers. I was working for the Australian government in 1975 when Gough Whitlam was dismissed by the Governor-General, Sir John Kerr, after a lengthy sets of letters, several hundred, with the palace. That was, I think, a wrong decision. And the nature of the power and what is called the reserve powers that the monarch may have need to be exercised in accordance with the principles of democracy. And in the case of Sir John Kerr, I don't believe they were. So there are some issues about the head of state. You also need, in a constitution, you need to have a legislature, someone who passes laws, and how you enact laws. Now, how laws are enacted in New Zealand is by the Queen in Parliament, or the Governor-General who signs on her behalf, because no law that's passed by the House of Representatives can become law until it receives what is known as the royal assent. Now, the issue is, what sort of parliament do you want? Are there any restrictions on its powers to pass laws? We've got now a Bill of Rights Act that was passed in 1990, but that Bill of Rights is an ordinary law. It is not entrenched. But we do have some entrenched laws, that is to say, laws that cannot be amended by a simple majority in the House of Representatives. And that dates back to 1956, when a National and Labour, who were the only parties represented in the Parliament then, they agreed that there were certain basic democratic principles like the secret ballot, like the Representation Commission, like the term of Parliament, things that were what the definition of population was, critical matters that if you meddled with them for party political purposes, that would be a mistake. So that is how it is that, for example, the recent Supreme Court decision about whether or not a 16-year-old should be able to vote, they made a decision saying, they made a declaration saying that Parliament should look at this. Now, that was, I think, a chink in the armour of parliamentary sovereignty, because we have a very extreme doctrine in New Zealand, more extreme, I think, than almost any other country, about parliamentary sovereignty. And what that means is that Parliament can do anything it likes. It can pass any law it likes. It can pass a law that orders the destruction of all blue-eyed babies, for example. This doctrine came to us from Westminster. It was the work of a constitutional lawyer called Albert Venn Dicey, who wrote, I think, in about 1888, his first edition, and it's been extremely influential. And of course, in Britain, what you have is adherence to that doctrine. But the British have got themselves into pretty heavy water constitutionally. Brexit caused constitutional crisis after constitutional crisis. It caused the government to lose votes in the Parliament. We've had 4 Prime Ministers since Brexit started, and some of them have been very brief. And we've also had journeys to the UK Supreme Court, which have, in fact, meant that the government has lost very big cases that go to the fundamental points in the constitutional arrangements in Britain. So we have in New Zealand always looked to Britain as a place that we drew our Westminster tradition from, and we are no longer a colony of Britain, and we need to stand on our own feet because we have a different political culture, we have a different sort of population, and we need to actually make our constitutional arrangements suit us. But it's extremely hard to alter the New Zealand Constitution. We have a constitutional tradition which is extraordinarily conservative and doesn't want to make change. And part of the reason for that is that every set of cabinets that you ever have don't want to make things harder for themselves. They want to be able to do whatever they like, and they don't like restrictions. They want to avoid having restrictions. And that constitutional tradition is also added to by the fact that we have a House of Representatives of 120 people, but those elected MPs, we do have a proportional representation system. That resulted from a 1986 Royal Commission that I set up, and that is a great system, but both the National and Labour parties opposed it when it was recommended, but the people voted for it at a referendum. So we got proportional representation, the MMP system. We got it against the will of the two major political parties, and they remain the two major political parties despite the fact that we have proportional representation. So if you look at the record of, we first had it in 1986 in an election, if you look at the record since, the smaller political parties have come and gone, but the two older ones have remained as constants. And the governments ever since then have been led either by National or by Labour. Sometimes they are majority governments, sometimes they are not. At the moment, we have a majority Labour government, the first one we've ever had under MMP, and that's a rather exceptional situation for proportional representation, I think. Now, that's quite a long way of saying that we have an unusual constitution, many elements of it are unclear, and that lack of clarity and the lack of knowledge of it on the part of the population, whose constitution it is a problem. Now, that problem can be summed up this way, that New Zealand is a robust democratic country. It has been ever since it was given responsible government by the imperial authorities in 1856. So we've had it since 1857. We didn't have foreign affairs power or defence power, but we had everything internal. So we've got a long history of democracy. We gave adult men the vote in, I think, 1879, and we gave all females the vote in 1893, so we were quite a progressive democracy. But the nature of it is because of its history. It has not been very good on Indigenous rights issues. The Treaty of Waitangi, which was quite well motivated by the Colonial Office of the day, was made, and the Colonial Office, the British, did not want to take authority over New Zealand unless there was consent from the Indigenous population, and the treaty efforts they made was to get that. But the difficulty was the treaty wasn't put into law, and the treaty is still not in law. Partly it's in law, there are references to it in various New Zealand statutes, but it is not part of the law. I tried to make it part of the Bill of Rights and entrench it in the Bill of Rights Act of 1990. But there was an enormous resistance to that, and you couldn't get it through. Well, we've done quite well with trying to redress Maori grievances under the Treaty of Waitangi with the Waitangi Tribunal, which is an important constitutional body in New Zealand. Maori have got a lot of issues that are not yet resolved properly. there has been historic injustice to Maori, and they are the tangata whenua. They were the first inhabitants of this land. And we really do need to take the treaty more seriously. That's why I tried to put it in the law. But the question of how much power Maori have, or should have, is an issue which Maori scholars have been working on for some years. And their work is quite advanced and quite elegant. And Maori have got to be a big part of this conversation, because they would be able to stop any constitution effectively. There are various groups that sort of would have veto power. That's the problem. But the difficulty is that we've still got hallmarks of colonialism here, and we need to wipe them out so that everyone has a stake in the society and feels part of it. And to do that, you need to have constitutional change. Now, to get constitutional change of any meaningful sort, you're going to have a government-run process for it. And you're going to have widespread public consultation about it. And you should have citizens' assemblies involved in discussing it, because unless it lives in the minds and emotions of the people, it won't happen. So we're at a strange sort of turning point in New Zealand, that if we, for example, became a republic instead of a constitutional monarchy, we would be obliged to make some changes. And we would have to decide what the head of state should do or not do. And we would then also have to define. The problem with New Zealand is that you don't want to put everything in a codified constitution. That would be silly. But you have to have sufficient so that the main outlines of the government system are clear, and you can't really easily depart from them, because the democratic train has to run on a set of rail tracks, and it shouldn't go off on tangents. So I think that is a pretty vital issue.
So in your recent book with Andrew Butler, A Constitution for Aotearoa, New Zealand, which we will talk about in more detail soon, you wrote, and I quote, that a constitution must rest on a popular foundation and facilitate the principle that majorities must have their will expressed in legislation. And I wanted to ask you, how do you understand the relationship between democracy and constitutions, particularly in the times we find ourselves today?
Well, because New Zealand is a very old democracy, and I think that form of government has served us well, we have to look at the challenges that democracy faces in the modern world, and they are profound and they are many. And because what a constitution does is define the relationship between the people and the institutions of government. And that relationship is basic and fundamental to the people and what they get out of the government. After all, it is a government that ought to be conducted in their interests. Now, when you've got an undemocratic or authoritarian government, it will not follow the will of the majority. Now, I don't mean that the majority have to get everything. They should not, because what you have to have is avoid having dictatorship of the majority to the minority. That's why you have human rights protections, to prevent unjust oppression of a minority by a majority. John Stuart Mill said that very well, and it's true. Now, the unfortunate thing is, in the last 15 years or so, democracy around the world has faced many, many challenges, including in New Zealand. COVID has not helped our sense of togetherness, our cohesion as a community, because people have got ideas about their rights which actually don't accord with the legal position in New Zealand. And they get very upset about that. But COVID has profoundly changed the whole atmosphere in relation to governmental power around the planet. And we're still getting over the effects of COVID. It had terrible effects on our economy, which has caused a lot of inflation that is currently going on. And people are very upset about that, and they don't like it. And the problems that COVID has caused everywhere, stress on the health system, inability to get medical treatment when you want it and need it, all those things came from that exogenous threat, which was a bit like the plague in medieval times, that you couldn't do anything about, but which they did invent vaccines that worked, and then there were issues about who got them and when they got them, and the amount of law that New Zealand made during COVID was absolutely enormous. I mean, we had law being changed once a week, lots of it, and we had to have press conferences the Prime Minister gave every day. But then they had to borrow a lot of money. Then the consequences for the economy, how do you manage the economy in the aftermath of that? This is a perfect storm and very, very hard to handle. And I think that you have to understand that the range of threats to democracy around the world, after all in Cambridge, there is a body called Centre for Future Democracy. And what they found in a 2020 report there was that dissatisfaction with democracies had spread all around the world. Not only did you have authoritarian governments such as in Hungary or in Russia, but you had a whole lot of other countries that were authoritarian and which were not making decisions in the interest of the majority. Now, just look at New Zealand. The terrorism risks we faced when we had the shooting of the mosque shootings in Christchurch was a terrible event for this small democracy. And it means that we have to have security intelligence services that are properly resourced so we can find out what those threats are and deal with them, and that involves a lot of secrecy, a lot of classified information, and a lot of lack of openness. But you look what happened. We don't want that happening again. Then you've got the war in Ukraine. Now, the war in Ukraine has had a profound effect on the international community. It has made security issues in Europe profoundly unstable. It has destroyed the rules-based system of international law, or threatens to do so. It has rendered the Security Council of the United Nations inoperative when you have one of the P5 members, Russia, vetoing stuff when it is conducting an aggressive war. How can a rules-based system you have any confidence in it when that happens? We've had a rules-based system since the end of the Second World War, and its life has been relatively stable. But that time has come to an end. And how you handle that internally in your own democracy is a question. We've had COVID-19, which, as I say, its aftermath has damaged our sense of social cohesion, it's disrupted our economy, and it's disrupted our international trade. Those are difficult things to handle if you're the government. We've got the developments in the United States, particularly the presidency of Donald Trump, and he's now trying to run again for president. That has polarised the American electorate more than ever in history. It has promoted conspiracy theories, the QAnon conspiracy and a whole lot of others, the Proud Boys. Trump has veered towards authoritarianism, and it was an amazing sort of government, and the prospect of it hasn't gone away. It may come back, hopefully not. Then you've got the UK troubles with Brexit. You've got declining standards of public behaviour, lies and scandals that have been discussed a great deal in the United Kingdom, and you've even got measures they've adopted, such as you have to have photographic identity to vote in a parliamentary election. Now, that is not a democratic method of going about things. So when you look to the UK and the United States, as traditionally we have for our democratic values, you don't see a lot that you want to copy. Now, we've also got quite serious issues with funding of political parties. Those issues mean that money buys influence. And if you look at the United States system, where corporations can spend unlimited amounts of money on freedom of expression to influence elections, that is an appalling system, but the Supreme Court of the United States has said that that's fine, that's constitutional. Now, we've also got quite big troubles, I think, from growing inequalities of wealth. The differences between the people who are very well off and the people who are not are much wider than they used to be in New Zealand society. And that is a great worry. Our need for transparency is very important in any democratic country. You've got to make sure that people can find out what is going on. We have an Official Information Act. We've had it for years. There have been two at least Law Commission reports saying it should be revised. They have not been actioned. Governments say they'll change the Official Information Act, but they never get around to doing it because ministers don't like it. They prefer to not have that information out. And I remember when I was the Deputy Prime Minister, I got a law reform officer into my office when we had the Official Information Act was quite new, who went round the ministerial offices to make sure they were following the law because they didn't want to. But I do think transparency is really important. Then we've got climate change. Now, climate change has to be transformational in terms of the measures that are taken. It's a very serious matter. We have got some machinery involved in New Zealand, but we haven't implemented most of it yet, and we're going to have to quite quickly because we didn't deal with climate change if we'd started earlier, it would have been much easier. We didn't, for political reasons. But most important of all, that the challenges facing democracy are disinformation. Disinformation, fake news, populism, social media, and conspiracy theories. They breed a mistrust in the institutions of government. And the institutions of government are the things upon which you citizens have to be able to rely. And Ed Coper, who's an Australian but has worked in America a lot, has written a book called Facts and Other Lies, Welcome to the Disinformation Age. I think that is one of the most serious problems that all democracies face, not only our own, but if you remember the occupation that lasted about 3 weeks on the Parliament lawn at the time of the COVID protests, you will realise that a lot of those people were down rabbit holes of conspiracy, that they didn't believe the science, they just believed, facts didn't matter. That wasn't true of all of them, but if you look at some of the journalism that's been done, the Stuff Circuit inquiry into that, it was very important. So what I'm really saying is that if you don't keep the machinery of democracy up to date, if you don't make changes to ensure that people have confidence in it, you will lose it. And it will slip away without you noticing, incrementally, one decision at a time, until in the end there's nothing left except authoritarian government. And I think that New Zealanders are sadly unaware of the challenges to democracy that we're facing. Now, I think that we value our liberty in New Zealand, and in order to do that, you have to have a workable democratic government based on principles. And I just think that What a constitution is about is the institutions of authority in a state, the powers of the state. And that means a parliament. How do you elect it? How many members should it have? What should it be able to do? You have to have a judiciary, judges who are separate from the decision makers, because if they aren't, you've got perfect dictatorship. If I make the law and then enforce it, mate, you've got no chance. I will put you in prison if I feel like it. That's not the way that our system works. The law is in the hand of independent judges who are not politically motivated. That is a vital matter. We also have the question of the head of state, which I've mentioned. That's important. And you've got to have some integrity institutions, things like the ombudsman, who look into the question whether there's been injustice done to people and they can't afford to go to the courts, because if you're going to have common law litigation in our court system, you've got to be well heeled. A lot of people don't have enough money to go to court, and you've got to provide them with some avenues to have their grievances looked at. And the Parliament's got to respond to people's desires in that regard. That's why you have a democracy. So I think that there are a number of basic principles that a constitution has to meet. The first one is that it has to be accessible so people can look at it and not to have to read a long book. And it has to be certain, or relatively certain. Because if it's not in one document, and you have to read a whole lot of unwritten constitutional conventions that may or may not exist, you've got some problems. I think you've got to remove the mystery. There's a lot of mystery, especially involving the royal powers. And our constitution that Butler and I put forward is designed to remove the mystery and provide an accurate map about how to govern ourselves. Now, the second thing that it ought to do is any constitution worth its name will educate people and public decision makers as well on their rights and responsibilities. A new constitution should help people participate in the democratic decision-making process. And they need to be educated about civics. How does the system work? And we don't provide that education. We've started changing. We're teaching our history now. When I went to school, we learnt all British history. Now we're teaching New Zealand history, and that's much better. But you know, the Constitution has to be trusted by people. They've got to know what it is, and they've got to be educated in it. Otherwise, you'll lose democracy. The third feature that any constitution should have in a democratic system is the rule of law. The rule of law is a fundamental principle. It anchors public power in a constitution, and that will contribute to the rule of law. And representative democracy needs a strong rule of law. All have to be equal in the eyes of the law. And you've got to have legality, and you've got to have fair procedures. Now, you've got to have, for that, impartial judges. The independence of the judiciary is a fundamental principle that you have to follow in a democracy. More important in some ways is democratic accountability, the fourth feature. You've got to provide a clear means of holding public decision makers to account to the public whom they serve on a continuing basis. That's true whether it's ministers, politicians, public servants, the police, the defence forces, or the judiciary. Now, elections are one form of accountability, and an important form, but not the only one. And one form of accountability doesn't fit all situations. Take the New Zealand Parliament, 120 members, 29 of them are not available to serve on select committees because they're ministers of the Crown or the Speaker. That leaves you with about a whole lot of MPs who are not part of the instrument of accountability. And in the current government, the instruments of accountability are really the opposition, and to some extent perhaps the Green Party, but they are part of the government as well. So what you have is very attenuated accountability compared with bigger parliaments. There are 630 people in the Parliament at Westminster, and we have an enormous government. We have government departments, government agencies, thousands, hundreds of thousands of people on the state payroll, and the accountability mechanisms in the House of Representatives have to keep control of the expenditure of all those agencies and their conduct and the propriety of their conduct. And you can't do that if you don't have adequate resources. Now, New Zealanders don't like having politicians. They don't want more. There's been a long resistance to having more MPs. But if you don't have more MPs, when you've got a system of government as big as we've got, you're going to have, in fact, no effective control over it. And I think things have reached that point now. I think the accountability mechanisms are inadequate. I've observed it over the years. The scrutiny of government legislation is much weaker than it used to be because there's much more legislation and it is greatly more complicated. And MPs have difficulties getting their minds around it. I went to the Standing Orders Committee a few weeks ago and told them I thought they had to do better because there's so many difficult issues you've got to look into and arrive at a view on. And it's a big challenge. Almost all parliaments have an upper house. We had an upper house until it was abolished in 1950. And it was abolished for good reason, because it was neither use nor ornament. It didn't do anything useful, and it was abolished. And I don't favour it being resurrected. What I favour is a bigger parliament with more MPs, where you'd have more talent and more choice, and you'd have greater levels of accountability that you could secure through it. Now, of course, that does involve the term of parliament involves the reserved provisions in the Electoral Act, and increasing the number of MPs would be a big decision as well. But if you don't do it, your accountability mechanisms won't work. Then you've got to get transparency. That means making the Official Information Act work better. You've got to protect the rights of citizens. I think that's really important, and that's done through two main mechanisms here. The New Zealand Bill of Rights Act, which has recently been increased in its capacity by being amended so that when a declaration of inconsistency is made by the Supreme Court, it has to be dealt with by the Parliament and not ignored, because the history of the New Zealand Bill of Rights Act ever since 1990 has been, well, we'll look at it, but we don't know much about it, and we won't necessarily, we'll just legislate these things away. Well, you can't do that. It might be convenient to ministers and others not to deal with them, but in fact, if you're serious about democratic principles, those human rights principles have got to be capable of being dealt with and resolved. And the history of the New Zealand Parliament with the Bill of Rights Act has been pretty spotty and sad. Another thing that I think about constitutional, you've got to be able to have a New Zealander as the head of state, because this is New Zealand, and you shouldn't have the head of state living 12,000 miles away. It sort of doesn't seem quite right, and my grandchildren don't understand why that would be the case. My parents used to call England home, but they'd never been there. My great-grandfather came here in 1842. So let me just say that your constitution ought to say a few encouraging things about national identity, about the preservation of elements of the system that have served New Zealand well, and what our aspirations are. It doesn't have to be, it's a sort of recital at the beginning. But we also have got to have protections against the abuse of power. You can't have government using arbitrary power that the law has not given them. And safeguards are very important, and we have quite a lot of them, but in many respects they need to be improved. The Constitution has to belong to the people, and it has to stand above any political party. You can't make the Constitution the subject of party political capture. If you do that, you'll have endless trouble. And I do think that the people need to have more say. It's very hard for them to penetrate the mysteries of the House of Representatives and how it all works. They do have the right to make submissions at select committees, but a lot of them don't know how to. And you'd be better off to really reform the whole instruments of engagement with the Parliament so that they have citizens' assemblies that when they make a policy, they consult properly about it, they get it right, and then it is enacted. We have a tendency in New Zealand, I used to say, to be the fastest lawmakers in the West. We pass a lot of law very quickly because we can, and we get it wrong, and so we change it the next year. That is not a great way to make law. And we're still making law in this country in much the same way we made in the 1860s. And it should be, the problems are so much greater now. You've got to try and get it right. But the 24-hour news cycle has sort of wrecked political thoroughness. You have to do it quick. They want it now. Yeah, but you get it wrong. I mean, when you're making law, that's not quite the same thing as making a speech. And we tend, the way in which social media has worked, social media has not had a good influence on the political process. It is, everyone has their say, but it's a total sea of total confusion. I think the media is an important matter here, and I think the media is part of the problem, actually, social media in particular. So I think that those 10 things are worthy goals to keep in mind. Well, what I'd have to say about that is that you will recall that in 1900, when Australia became the Commonwealth of Australia as a result of a law passed, 1901 it might have been, passed by the Parliament at Westminster. That was preceded by a whole lot of constitutional meetings in Australia to which New Zealand was invited. The covering clauses of the Australian Constitution Act still say that New Zealand could join, but it would require, I think, a statute of the Commonwealth Parliament to allow that to happen, and I don't anticipate that New Zealanders would want to join the Commonwealth of Australia because the difficulty they have in Australia is the federal system is very clunky, complex and difficult. And a unitary state has many advantages. It can pivot more quickly to deal with the problems it's got. The constitutional tradition here, therefore, to change to a constitutional convention of the sort that they have in the US when they're doing state conventions, and I'm familiar with that, would be such a novel idea that you would spend many years trying to get anyone to ever engage with it. You would be better here, I think, to deal with a proper government process, set up a royal commission, which is the traditional way of doing these things. We did the electoral law changes that way. But as part of that process, you would have citizens' assemblies. You would have them from Maori, you'd have them from Pākehā, you might have them from other groups to find out what their views are so that you can join it. The Irish have had great success with this. They've transformed Ireland in ways that one wouldn't ever expect because of the creative use of citizens' assemblies, selected on a random basis, but given a lot of resource to be able to think its way through the issues. And I think that to have a constitutional convention of the sort they had in to set up the United States Constitution, and the problem with the United States Constitution is that you can't amend it. It's too hard. And it's therefore not responsive to the people because it can't do anything. You've got a system of government that is based on stasis. You have to have the President, the Senate, the House of Representatives all in agreement before anything happens, and they're all separate parts of the government. You do not want an American system. People often say to me that I'm trying to put an American system in here. I am not. I want a Westminster system that works better. So, but there are some big issues in all of this, but you've got to have the book that Butler and I did. We put in everything we thought should be on the agenda. We didn't think it would pass that way, but we wanted to produce a situation where the government would take seriously the idea that constitutional reform should be engaged in and set up mechanisms to engage in it that were effective. Now, the problem that you got with that is that politics speaks the language of priorities. Cabinet sets the priorities. It's not on anyone's priority to have a written constitution because no one knows what good it would do or what it would be, and so you ignore the issue. The dangers of ignoring the constitutional issues is that they start to fester and your government system gets worse and the quality of it deteriorates. And I think the best thing that I should read you is the wonderful language of my old colleague, Professor Robert Quentin Baxter, who I taught constitutional law with here in the mid-80s. No, the mid-70s, I'm sorry. He said this, and it's really worth bearing in mind. A constitution is a human habitation. Like a city, it may preserve its life and beauty through centuries of change. It may, on the other hand, become either a glorious ruin from which life has departed, or a dilapidated slum that no longer knows the great tradition of its builders. I think that is a profound statement. And I think people in New Zealand should take an interest in their constitution if they're interested in having a healthy democracy.
Good. So, Sir Geoffrey, constitution-making processes usually get started because there's some kind of consensus that major constitutional change is needed, and that there is a need to rethink fundamental aspects of the Constitution. At the moment, I can think of two possible candidates for triggering such a situation in New Zealand. One is something that you already mentioned, which is the question of republicanism, which is perhaps not a big issue right now, but maybe it will become more important to the incoming generation. And also the question that you have also mentioned before, the question of Maori self-determination and of the possibility of transforming the constitutional order in a way that more clearly recognizes claims to Tino Rangatiratanga. How do you see these prospects? In other words, how do you see the future of constitutional change in New Zealand?
Well, the difficulty is the constitutional moment in New Zealand never arrives because the level of public discussion about it is very thin. We spoke to 3,500 people, Butler and I, around New Zealand. There was a lot of interest in it, but it wasn't really taken up by the media, who can't really take these discussions very far because it doesn't suit the news cycle very well. And the second thing about it is, unless you have a government commitment to looking into something properly, it won't happen. And we have been trying to generate an atmosphere for that because I think it is far better to try and deal with the problems when you haven't got a crisis on your hands, because if the constitutional moment of a crisis drives the process, it won't be balanced. And that I deplore. I want good work done in depth in order to make this happen.
Very good. Thank you. Thank you very much.
Right.
Yeah, that's great.
Thank you.
Thank you.